So the topic of today is machine learning, managing the AI and the associated risks in a regulatory environment. So we're going to jump right in. Susie, why don't you tell us about what are the upcoming regulations, guidelines that data scientists should care about?
Okay, it's a great question. First of all, I'd say the whole world is trying to figure this out. There is a scramble around the world to figure out what rules we need to apply to AI. There is a lot of conversation happening right now around trustworthy AI. So how do we make AI transparent, legal, and beneficial? I'm going to answer that question really focusing on what I see as 3 themes emerging in this space where people are trying to work toward trustworthy AI. So the first theme is a split between private and public. And by that I mean we're seeing regulations that apply to government use of AI, and then different regulations that apply to private sector. So there's this private-public split. And I think it's important for private sector to pay attention to what's happening to the public sector, what the governments are doing, for 2 reasons. One, if you're building systems that you want to sell to government, you're going to have to comply with whatever rules apply to the government. And number 2, the focus predominantly seems to be starting in the public sector. So it could be a bit of a bellwether for what's to come in the private sector. I think an outstanding question to consider going forward is how much sector-specific rules, guidelines, or regulations there should be. We can see that the issues can be different in policing from, say, financing when using AI. But do we want to get more specific than that and have sector-specific rules applying to, say, AI in the insurance industry, AI in the health industry? And those are sort of questions that are evolving. So that's the first one. The second theme we see emerging is this idea of how do we get there, right? We want trustworthy AI. I think everybody kind of wants to maximize the benefits we can get from AI and minimize the harms. So what's the best tool? Can we get there with guidelines and principles, which we're seeing developed all over the place? Different companies are developing their own, different jurisdictions are developing guidelines. Or do we need something with more teeth, something that actually has some sanctions attached to it, some law or regulations? Currently, the province of Ontario released in January 2022 their beta principles for AI that's being used by government. This fall, the US released their blueprint for trustworthy AI, and it has, I think, 5 principles. The EU has another list of principles. The federal government in Canada is taking it a bit further, and they have developed, I think they were a bit of a pioneer in this context. They, in 2018, they rolled out their federal directive for AI. So any federal Department of Canada that is subject to Treasury has to undergo an algorithmic impact assessment. They were the first, I think, in the world to create this. And then recently, you're probably aware, they developed a draft legislation last spring, which I think has gone to first reading, Bill C-27. And this applies to private industry, if it is enacted. This act is significant. It comes with significant sanctions and penalties, and introduces regulatory offenses in this context. So that's a question. Do we want guidelines and principles? Do we want rules? And then finally, the third sort of theme we see emerging is how we want to categorize AI systems. How do we want to assess them? Are we going to assess them? What we see emerging is an assessment based on risk. Seems to be a big focus right now in this sort of the world chasing how we assess risk in an AI system and what does that look like. Now, for industry, sometimes risk is, what is the risk regulation is going to come and impede my business? Risk is also, how does it impact an individual's rights? So these are sort of 3 emerging themes we see in the regulatory context. Does that help?
Yeah, thank you. As a technologist, I definitely find, like, every time I listen to Susie, is, wow, there's so much about law and regulations that I don't understand. we were actually recently at Factor Institute at their Managing AI Risk Thought Leadership project. So some of the risks that the group thought about and really paid attention to are, some you may already know, like bias, data privacy, model risk, cyber security risk when you're talking about using AI models. So what can organizations do to, as a result of these upcoming regulations, what should they do, right? So some of the things that from the industry we've heard, and Fairly AI, just give a little bit background, we're a Toronto-based startup, but we were in Accenture's FinTech Innovation Lab out of London, UK last year, where we talked to 14 tier 1 banks and insurance company. So some of them are already, looking at these upcoming AI regulations and how to, be ahead of those, right? One of the comments we heard from someone that is actually at the Bank of England public-private AI forums that the necessity of documentation is only going to increase, is one field. Because when you talk about transparency, accountability, it all boils down to having evidence, and that boils down to documentations. But there's also this mentality, actually, of data scientists thinking that they should just wait till the regulations come before they do anything. But the worst case that we've heard is, okay, do your bias fairness measure right now, but just don't document anything, until there's like clearer guideline and regulations. Would love to hear what your view is, Susie.
I take a bit of a different view than that. So the impending regulations are significant to pay attention to, but we actually have pretty robust laws that currently exist that people should already be paying attention to. And there's 3 that I would highlight. One that gets the most attention is privacy. That was people very quickly clued into conflicts with AI's insatiable need for data, which includes personal information, and how that can cause problems for people's individual privacy. I think that's expanded beyond how we manage people's individual data and the concept of anonymization and the shortcomings with anonymization. I think it's expanded to bigger concerns with a larger societal question about surveillance and how much information do we want corporations or government or other people to have about us and what they can do with that information. I think that's a bigger question ahead. But privacy is one. The second one is this idea of fairness that gets a lot of talk too, fairness and accountability. And people, again, if they're going to trust a system, they have to think that it's fair. And that ties into a lot of the conversation about transparency and explainability. How much can we understand about the system? I spent a lot of my career litigating, and to litigate one of these systems would be so complicated. But typically the law wants to understand how things worked. And that just comes into conflict with the black box system, right? What type of understanding can we have? How can you justify the decision that the AI system produced? So that we get a bit of rub there. And then the third issue, which I'm spending a lot of time on these days, is the human rights. And there's a lot of talk about bias, a lot of talk about statistical analysis. But I think we take these very, very complex AI systems, and then we take an incredibly complex area of the law and just smash them together. And it's hard. Arguing a human rights case at court is, I told Fion this example. The last decision that came out from the Supreme Court of Canada on human rights involved a workplace environment, and it was 4 women who made a complaint to their employer in the year 2000. And they went through the internal process in their own employment context. And then eventually it made it to court, and they went through all levels of court. And the Supreme Court decision came out in 2020. So that's 20 years of, they came out in favor of the 4 women who brought their claim, but they're hard cases. It's a 150-page decision that goes into a lot of detail about systemic discrimination. So we're starting in a difficult place if we're going to litigate these cases. But we have a robust human rights system in Ontario. We have the Charter, which applies to all government, are subject to the Charter. We have the Ontario Human Rights Code, which applies to everyone. And we have the Canadian Human Rights Act, which applies to federally regulated industry. And the entire purpose of the Ontario Code is to eliminate discrimination. So we already have a law on the books that says you can't discriminate. And a few little high notes on this area of law is that human rights trumps everything else. It's paramount. So our Constitution is the most important law, and that's what the Charter is part of. Human rights code is quasi-constitutional. If there's any conflict, human rights wins. And our human rights are supposed to be interpreted very, very broadly. There's also in Canadian human rights law, there's no requirement to have intended to discriminate. In other words, if you didn't know your AI system was discriminating, that's your problem. You have a positive obligation to ensure you're not discriminating. This is very different than US law, where the intention is not part of it. Another sort of interesting part about our human rights law is it's based on the principle of substantive fairness. So substantive equality. And substantive equality means sometimes if you treat everybody equally, it could end up in unequal circumstances. Sometimes you have to treat people differently in order for people to be equal. And that's part of our law. So this causes some challenges with AI. But I think these are areas of law, since they already exist. You can wait for regulations, but you should be talking about human rights now. I really see it as a ticking time bomb before there will be massive litigation over a system. It'll probably be a test case, because we've already seen it in the US, in the Netherlands, in Australia, where they've had massive human rights issues with AI systems there.
That's ticking time bomb. So that is good overall view of what companies need to do. I know time is going by fast. Any final thoughts on what else organizations should do to prepare for upcoming regulations?
Yes, I think there's a few things. One is thinking of AI as needing a diverse team. It's not just computer science. When you're designing a system, you need lawyers, you need policy people. You should be talking to the people who are going to use the system and talking to the people who are going to be impacted by the system, ideally, right? Involve everybody in the discussions. That's one. Two, do your basic due diligence in terms of human rights and law. Look at the issues. If you start thinking of human rights from the beginning, then you're going to be better off. And the three, I would say, become familiar with impact assessments. You could spend about 5 minutes, maybe 10 minutes online, and you could find 10 AI impact assessments. One of the highest profile in Canada is the federal directive that I referenced before. Microsoft has one, the European Commission has one. Start looking at them. It's not a foolproof way, but start assessing your systems. And the third thing I would say is really look at these issues as part of the life cycle of AI. So you need to start thinking about these issues early on in the design phase, the implementation phase, once the AI system's in use, and as it continues to be used, you should be constantly looking at these issues because they develop and morph. Those are what I'd say are the 4 things that people can be doing. I think there will be a lot of trial and error. I mean, from the legislative regulatory perspective, it will be, let's see if we can figure this out, let's adjust, modify. That was actually built into the federal directive. They had to review the law every 6 months. They're now changing that because that's a bit aggressive, but I think that's the way we need to see it going forward.
So one of the points I like that you made in previous discussion we had was the law is not going to tell you that the accuracy score should be 94%.
Okay.
Can you expand on that a little bit?
Yeah, I know that's one of the challenges is that goes to sort of how complex the human rights analysis is. Statistics are crucial. They are a crucial element of a factual sort of evidence that can go to show there is discrimination. But what level is okay and what level is not? I think maybe we can get there eventually, find out what's acceptable. It's incredibly context specific in terms of if your system, I don't know, can't think of an example, but if your system has 70% against one portion of the population, is that okay? Or is that not a good thing? Where is the line that we draw? Currently in our human rights law, human rights experts are sort of opposed to coming up with any standards. And the Supreme Court has been clear saying there's no hard and fast rules. It's all context specific. It doesn't really help when you're trying to figure out whether your system's a problem or not. But I do think there are questions you can ask to find out if you're in a problem area. We at the Law Commission are coming up with our own impact assessment with the Human Rights Commission of Ontario and the Canadian Human Rights Commission to design an impact assessment. It's not foolproof, it's not going to be perfect, but it is supposed to help people get an understanding of whether their AI system is going to have some human rights implications or issues. I mean, a lot of them won't, right? A lot of systems are just not going to cause any problems. It's really just the ones that might, it's probably a small percentage that would actually cause significant human rights issues, is my guess.
Thank you. Yeah, I think that's the solution that we all look forward to, having that assessment from the Law Commission of Ontario. So my final thoughts is really that I agree with Susie, like you should start from the beginning as you're building responsible AI. You simply cannot reverse engineer a lot of these AI models once you have started. So starting from the beginning is what we see. So going back to Fairly AI started with the banks, but honestly in the last 6 to 9 months, we're getting inbounds from people who are doing AI outside of financial services because they realize the benefit of doing responsible AI as a competitive advantage. So they're not waiting for the regulations to drop. It's where the more forward-thinking companies are doing, and they are doing it because they know the regulation's coming, they want that business continuity, and like Susie said, it's like a lot of trial and error. So at this point, like a lot of them are doing it as like trying to figure out what the right process and procedures are. And they know they're not going to get it right the first time, but they know they have a little bit of time. But as long as they are starting to do something, they are already ahead of their competitors.
I also really like your point, Fion, about record keeping. I think record keeping is very helpful. At the very least, you can say we took all these steps, we made a lot of effort, and we sought advice. We did everything we could. It's not necessarily foolproof, but that's a smart way to go.
Yeah, that's a good point. So here's another tip from the industry. Honestly, that's our door openers when we go and tell the data science team that we're helping you do boring documentations, right? We've talked to banks where they are considered most AI ready and highly regulated industries. I don't know if there's any bank data scientists here, but I've been told at some banks, like they build one model and they need to produce 72 reports, right? So I think a lot of industry are not as highly regulated, but the fact is with upcoming AI regulations talking about accountability, transparency, it definitely translates into a lot of documentations. Record keeping is the other word for it. So, and that's why we exist. We help companies, do proper AI governance, risk, and compliance, and then start with boring documentations. With that, I think thank you, Susie, for being here with me today. Again, I think we are all trying to build the ecosystem together, so happy to discuss. We're actually running an early access 2.0 program at Fairly AI. We already have some amazing companies to come along with this journey with us. Happy to chat if anyone's interested.
I would also say that if anyone's interested in the human rights impact assessment that we're working on, we will be starting consultations in the winter. And we're really keen on talking to anybody who is interested in, we want the tool to work. We want it to be useful to people. So if anyone's interested in talking to us about what we're doing, that's most welcome. Please reach out.
Thank you.
Thanks. Are there any questions?
I think there's a question.
I have a quick question here. So you're talking about the
how much are guidelines critical to the police force?
Yeah.
Is that what you're saying? Well, the police, I mean, the police is a interesting area. Originally, we had Dave Cobley from the RCMP here. I think it's crucial. I think we probably, in that context, we need something more significant like rules, regulations, laws. The police have a very important job of keeping our communities safe. Right? That's crucial. We have to balance it with their power to take away people's freedom. So it's what we hold most dear. So they're high stakes. And then you add on top of that, in Ontario, our criminal justice system is overwhelmingly overrepresented by racialized, vulnerable communities. So you're already in the context where you're dealing with disadvantaged communities. So the human rights issues are significant. And then also you have, sometimes a hesitance towards transparency. The police don't necessarily want to share it with everybody what they're doing. They want to be able to catch the bad guys without showing them all their tricks. So there's you can see these conflicts here. And but anytime, I think given the police's potential, the significance of the human rights and risks involved in terms of surveillance, in terms of taking away someone's freedom, having that power, the power the police have, I think it's heightened of importance. So guidelines, maybe, but even probably more. Another difference, though, is there are more rules that already apply to the police, right? So there's a whole body of law around criminal procedure, and the charter, part of our Constitution, has sections that are written specifically and only to apply to police, to rein in police powers. So that exists to some extent already. But yeah, and we're also, not to plug our work, but my colleague is leading a project on AI in the criminal justice system and looking at specifically what rules need to exist in that context. I don't know if that helps your answer, but I will say my own personal view on this, and I know I'm speaking to industry, which some of you are probably like, regulations slow us down. They just get in the way. I know lawyers are a royal pain in the rear end, but I like to think of this sort of working toward trustworthy AI, and I sort of got this idea from one of my former colleagues. When you want trust, we have to know what's going to happen when trust is broken, because sometimes people break trust. And if we know what's going to happen when it breaks, we can have more trust in the system. And so that's sort of where sanctions come into play, and seeing them as more of a tool to support trust rather than a drawback is sort of how I would look at it.
Thank you so much for sharing your perspective. Greatly appreciate it. I do want to make a comment that I work directly with our privacy team, so as soon as we start a new product, they're one of the first people I connect with, so they don't slow us down. My question for you today is, as data scientists and owners of data products, we focus on de-identifying identity. We also make sure that our users, our patients, are consenting to the way that we use their data. Today I saw that there was a strong focus for equality and anti-discriminatory practices for how data is used. But I'd like to ask you, is there anything else that our data scientists and data product owners should be focusing on other than de-identifying and consent and also equality? Are there any specific examples?
Of other things to be looking at?
Yes.
That's a really broad
Or
question.
is that it? It's easy if that's it.
I can't answer that question in absolute, because I will walk out of this room and 10 minutes later be like, oh, and this, and then you need to think about this, and you need to think about this. But that is such a broad question. So I would say thinking about, you've got privacy and what you're doing with individuals' data. What remedies do people have? What recourse do they have if their data is incorrect or used in ways they don't want it to be? What control do they have over where their information is going and who's holding it, and whether they can alter it? Then the bias, what are the unforeseen, there's so many unforeseen outcomes with AI that trying to think about how it will be, what the impact will be down the road. And then I would spend time on this sort of transparency aspect of it. How much information how much notice do you need to give people about the fact an AI system is being used? What disclosure do they need to have? How much do they need to understand about the system? Yeah, and sort of get into the idea of the explainability and disclosure context of it. I'd say those are the three elements.
So can I add one more thing? So California has that new law coming up in 2023 where people are allowed to opt out of AI, right? So one of the things we discussed at Factor Institute's thought leadership project was just that, like, sure, you can get the consent, people can opt out, but then what? How do you actually manage it? If you've used their data to train an AI model, doesn't mean you have to go back to all your product and retrain every single model. There's something that isn't really clearly defined in the law yet.
Yeah, I think there's also a lot of work to be done in the concept of consent. You know, the click consent contracts that everyone does online. I'm not quite sure how those are going to work going forward, because is anybody actually really giving their consent? They just want to use the product. They're not really understanding what they're consenting to. So I think there's a lot of work to be done in that context.